water worth more than gold? Constitutional rights-based approaches to glacier protection in Argentina. So without further delay, I will hand over to Dr. Asmaa Khadim. Dr. Asmaa Khadim is a postdoctoral researcher in Institutions for Conflict Resolution, which is a research project implemented as part of the Dutch National Sector Plan for Law at Leiden Law School. Her research centers around environmental constitutionalism with a primary focus on comparative constitutional law, environmental and indigenous rights, natural resource conflict, cumulative impact management, and government accountability. But before I hand over to you, Asmaa, I'd just like to remind everyone who's joined us today to please feel free to engage in the chat. You can share your questions, your comments, greetings, and introductions in the chat box. And during the discussion portion, you're also welcome to raise your hands and unmute to ask your question or to make your comment. And just to check very quickly if Dina wanted to say a few words as well, or if we can go straight over to Asmaa. But Dina, over to you first.
Just to echo Angela's welcome on behalf of the GNHRE, we're very happy to have Asmaa here and we're very excited about this talk. And I don't want to take up any more time.
Thank you both, Dina, Angela, and the rest of the organizing committee. You guys have worked so hard to put this together, and it's my first time actually being a part of this summer school, but I was quite excited to join and really looking forward to participating. So if I could just have the next slide. Just a bit about me. I'm just waiting for that slide. Okay. Thank you. So as mentioned, I'm a researcher in Institutions for Conflict Resolution at Leiden University. And my research focuses mainly on environmental constitutionalism, human rights, and resource conflicts, so largely focused on mining conflicts. I completed my PhD at the University of Queensland. And during my doctoral research, I undertook a comparative constitutional analysis of jurisdictions that had environmental rights protection with those that did not. And one of my case studies was in relation to Argentina, and it's that portion of the research that I'll be sharing today. Unfortunately, we don't have enough time to go around and have each of you introduce yourselves, but it would be nice to know where you're from. Since we're talking about constitutional environmental rights in this lecture, the topic tends to vary from country to country, and some countries have constitutional environmental rights and some do not. So in the chat bar, if you could briefly state your country and location, it would give me a bit of a sense of your background and whether you come from a jurisdiction that has constitutional environmental rights, similar approach to Argentina or not. So someone from Spain, anyone else? Italy, okay, yeah, France, so across Europe. South Africa, definitely have constitutional environmental rights there, one of the most famous constitutions, I think. Nigeria, Brazil, yeah. I believe it has constitutional environmental rights, but enforcement is a bit all over the place. Anyone else? Okay, so just moving on. If I could have the next slide, please. Just a brief background on what are environmental rights. So before we turn to the specific topic of the lecture, for those of you who might not be familiar with the topic, it helps to know what we mean by environmental rights. The most common assumption is that environmental rights are laws that deal with pollution and environmental regulation. But even though they're related, they're not the same thing. Environmental law is a collective term that describes the regulation of the effects of human activity on the environment. So this kind of regulation addresses things like environmental pollution or management of specific natural resources like forests or fisheries. Environmental rights have a less clearly defined role in the field of environmental law, and environmental rights essentially capture the environmental dimension of human rights. There's been a lot of debate in the literature about what's included in environmental rights, but a majority of scholars agree that the right to a healthy environment is a human right. And this position has been strengthened with recent recognition by the UN Human Rights Council Resolution 4813, which urged nations to adopt stronger environmental laws and enforcement to protect the very foundations of human life, which are based on a safe, clean, healthy, and sustainable environment. So concepts like sustainable development or intergenerational equity or public participation are connected to environmental rights. Just the next slide, please. So what do environmental rights encompass? What is it actually meant to be protected? In 1994, the UN Special Rapporteur released the draft Principles on Human Rights and the Environment, which is considered to be the most comprehensive articulation of environmental rights to date. And that was one of the readings for this lecture. So you can have a look at the report. It's quite lengthy. Essentially, the Santini report looked at the various dimensions of environmental rights, including both substantive and procedural elements, as well as the relationship between environmental rights and other human rights. So it's considered to be a right that's interdependent with other human rights like housing and land rights, indigenous rights, amongst others. And that makes sense if you stop and think about it. An environment that has poor water and air quality and cannot support adequate vegetation or wildlife may be one that cannot support humans as well. So then what happens to basic notions like the right to life? So our human rights can be violated as a result of environmental degradation. Environmental rights also encompasses the procedural protections to ensure those substantive rights, so participatory rights, which we hear a lot about, like the rights to information regarding the environment, the right to active, free, meaningful participation in planning and decision-making. And in addition to this, the environmental rights will include aspects that emphasize responsibility on the part of individuals and governments to protect and preserve the environment. So we're talking about individual responsibility and government duties. Unfortunately, the draft principles failed to secure the backing of states. They never attained treaty status. But still, I like to refer to them in the beginning because they serve as a useful reference point when we're discussing environmental rights. They're based on such a comprehensive analysis. Moving on to the next slide, please. So once we know what environmental rights are, this naturally leads to questions about how best to protect and enforce them. And generally, there are three ways that countries will deal with environmental rights. We see entrenchment within domestic constitutions, and that could be at the national or the state level, or both. Constitutional environmental rights provisions within national constitutions are framed in a variety of ways. So some constitutional provisions refer to a government duty or individual responsibility vis-a-vis the environment, while others will protect a substantive right to a healthy environment, and still others will protect only procedural rights. So depending on the country, this can be framed in a variety of ways. Environmental rights can also be protected through federal or state legislation, or perhaps they're not dealt with at all. And some of the existing research shows that places with constitutional protection have stronger environmental laws and better environmental performance on key indicators. The research of David Boyd jumps to mind in particular. But the problem is that, you know, one of the ongoing debates is that there could have been any number of contributing factors aside from constitutionalization that led to these outcomes, such as political will or a strong regulatory regime or judicial activism. So we may not be able to form these broad generalizations about the benefits of constitutionalization. Not everyone agrees that it works or that it's a good thing. And that's where we start to see gaps in the literature. And we need to know how constitutional protection might contribute to greater environmental rights protection. What are the benefits? What are the drawbacks? How are these rights operationalized in practice? We also have to try to identify institutional or other types of barriers. So this is where it's important to look at particular jurisdictions and particular conflicts in greater detail. How do these play out? And what can they tell us about constitutional environmental rights? Next slide, please. So it's interesting to note that many countries have taken steps to protect environmental rights through entrenchment within their national constitutions based on the idea that environmental rights should be included within national constitutions in the same way as other human rights. And a sizable majority of the world's nations now recognize a right to a healthy environment as a constitutional right. So you can see from the map, most of the world's nations have provided for some degree of formal constitutional protection for the environment. The light green areas are countries with some type of constitutional provision for a healthy environment, while the dark green areas are countries that specifically have a constitutionally protected human right to a healthy environment. And a right implemented through a national constitution is considered to have more force because constitutions are generally considered the supreme law of the land, Constitutional provisions are applicable to all levels of government and trump statutory law. So as documents that both allocate and constrain government power, national constitutions may be essential to reframing our normative conceptions of law, nature, power, and rights. Next slide, please. Before I move on, I thought it might be nice to take a little break and working in small groups, consider the question of how environmental rights are protected in one country of interest. Perhaps it's your home country. Is it constitutional? Is it legislative or some other way? And if you do find this protection, is it framed as a substantive right or a procedural right? Or is it based on a government duty or individual responsibility? And I'd also like you to consider whether or not it is broadly worded or narrowly construed. So I had allocated about 10 minutes for you to work on this, and then we'll come back and discuss. So it might be a good idea to just work in pairs since it's a small group. Dina, Angela, shall I include you in the breakout session? Would you like to be part of it? Okay, sure. Okay, let's try this out.
Hello.
Hi.
Hi. Maybe I'll just pause the recording for our room so we can just chat.
Okay. So I'm interested in hearing which countries you looked at and whether you found any constitutional rights protections or if there was some other legislative protection for environmental rights or nothing at all if you struggle to find anything. Who wants to give it a shot?
I can start us off.
Sure.
I was in a group with someone from Brazil and someone from Bolivia, and I'm from South Africa. And one of the things that we thought was really interesting was how similar the circumstances are in all of those countries. So they're all countries with very strong constitutional, legislative, and regulatory protections for the environment and for environmental rights, but they're all countries that in many ways kind of fail to realize those rights, either through sort of box ticking processes in which they pretend to comply with the law but don't, or through efforts to undermine constitutional provisions through kind of ever more specific regulation, or through kind of violence towards environmental defenders. We found a lot of overlap between our three countries.
That's very interesting. And so I guess, first of all, you bring up a number of really interesting points. I'll try to remember them all, but refresh my memory if I don't remember it. I think that what's interesting about Argentina, it's not what you would call in a blanket sense a success story, but there are some successes that we can look at and maybe use as a guide to understanding other jurisdictions that have similar problems. So in that sense, I find it very interesting. I do think that what you say about box ticking or finding legislative means to narrow the provisions really leads to broader questions about substantive rights and what it means to actually give effect to a right in a substantive sense. And that's where the role of the judiciary becomes very important. That's where the environmental ethics of a place, kind of a culture exists around environmental protection becomes really important. And of course, rule of law and the safety of environmental advocates as well. So all of these things overlap. It's not so simple as just saying, okay, we've got this provision on the books, therefore it solves, all of the problems. Anyone else? What other jurisdictions did you look at? Let's hear from the people from Spain or Italy or France. Do you happen to look at those constitutions? Fernando? You've got a hand up.
No, sorry, can you hear me?
Yes, I can.
Well, yes, so in the case of Spain, for example, we don't have a fundamental right as such in our constitution. We have some constitutional provisions that protects the environment. And I would say that here in Europe, we are really influenced by the European Union, and perhaps we don't have really strong provisions, but in some way, because we have like a lot of, for example, in Spain, a lot of administrative legislation, the protection in somehow is narrow, and we can like cover more or less everything. But yeah, I think that this is like probably the division, that some countries do have really strong constitutional rights and some others don't. But that doesn't mean that the countries that have like probably like weak provisions, the protection is worse. I think that in the end, it really depends on all the laws that are behind that constitutional provisions.
Yeah. So in the European context, do you think that the European Convention on Human Rights might become relevant? Do you know of any litigation under that? I'll give someone else a chance to. Catalina, you had your hand up. Your microphone's off.
Okay, can you hear me?
Yes.
Okay, so I was in a group with someone from Kenya, and as I also live in Kenya, we decided to choose Kenya as an example. And we saw that in their constitution, the right to a healthy environment is recognized. So it is a right recognized at the constitutional level, and the constitution considers both substantive and procedural rights, and it is a duty of the state. However, citizens have also the duty to cooperate in this regard. And some procedural rights are, for instance, procedural obligations will be impact assessments, for example, among others that we saw in the Constitution. Thank you.
Thank you. So basically, they've got sort of all of the dimensions covered in their constitution. We're talking substantive, procedural, government duty, individual responsibility. And I guess the question then would be, how are these enforced? How are these implemented? Do you happen to have any knowledge of any litigation around this? Have the courts considered these provisions? I know that's not a question I asked you to pursue. I'm just wondering if you know off the top of your head. Catalina? Your microphone's up. Yeah.
Yes, I need you to give me the permission. So the Constitution considers the enforcement of environmental rights. So if I think that my right to a clean and healthy environment has been or is going to be denied, violated, or infringed, I can go to a court for redress in addition to other legal remedies. But at the top of my head, I cannot come with any particular example for that. But it is considered in the Constitution, the enforcement of environmental rights.
Yeah, I would be curious to know if the courts have considered it. Baina, I'm not sure if I've said your name correctly. You have your hand up.
Yeah, thank you. Thank you for the presentation. It's very interesting. And I was going to answer to your question concerning the ECHR. Yeah, sure. The ECHR can, in the case law of the European Court of Human Rights, is a great source for the protection, for the environmental protection, and the court did it, even though the European Convention of Human Rights does not contain any right related to the protection of the environment, and the court is underlining every time in its judgments that the convention is not dedicated to this, but through some human rights, it is possible to protect the environment, namely through the right to life, right to family and private life, through even the right to property, and it's if I talk about the substantive rights, but also through the procedural rights, in order to ensure to individuals the possibility to access to the justice, and to make their right to healthy environment, or through other aspects to protect their rights. So yes, ECHR is there, and when as it was told by, I don't remember, I'm sorry, the name of the person from Spain, and yes, and Spain, as it is the part of the ECHR, of course it will be influenced, even though there is no provision on the national level. So it's going to be through the indirect influence, but there is also the EU, as it has been told. Yes, and Eduardo Agostinho case, it was a climate change case. It's
right. So that was one, thank you for that. That was one option that actually isn't on the slide, which is reading into other constitutional rights. So that's another way the courts sometimes get around, the fact that it's not expressly provided for within a constitution, but perhaps we can read it in. Any other thoughts before we move on? Anyone else would like to share? Okay, so we've considered a few different ones. If I could have the next slide. Essentially, why would we advocate for constitutional approaches? A lot of scholars advocate for it. And the reason is, if you think about constitutional rights have the benefit of not being easy to do away with. Constitutional amendments are a bit more difficult to obtain, as compared to legislation. Legislation can be repealed with greater ease, but apart from that, constitutional environmental rights have also been linked to improved environmental performance, stronger environmental protection, better court decisions on environmental matters. And David Boyd's research found that by 2012, it was, at least 44 nations had court decisions enforcing the right, and the number has since grown. Courts in dozens of countries have held that the constitutional right to a healthy environment is binding. Constitutional recognition of these rights can increase access to justice and bring about a more transparent, deliberative, and accountable government if other conditions are met. They can also offer public stakeholders the ability to overcome issues of standing and potentially even address power imbalances and inadequate responses by government actors that are responsible for ensuring public interest. So essentially, constitutionalization can benefit those who are directly impacted by development by offering them legal mechanisms for addressing substantive issues. So if local communities are concerned about inadequate environmental protection or climate mitigation efforts on the part of governments, they are increasingly able to turn to the judiciary to litigate environmental rights claims with some success. I would say mixed success. It depends on where you are. And it also depends on what's at stake sometimes. But essentially, local communities are sometimes in the best position possible to understand the potential impacts of a proposed development, impacts to water quality, access, impacts to local wildlife that might be observed in daily life. And given that the stakes might be highest for them, they're often more highly motivated to take actions. So for example, if your water supply is threatened, you might be more likely to take action to protect it. You simply can't survive without it. So there's a lot of examples out there where public stakeholders have successfully taken action in court pursuant to these constitutional environmental rights provisions and gotten judgments to halt environmentally harmful activity or require cleanup of pollution or to require government actors to provide better management and oversight of development. So the examples I've spent a lot of time looking at relate to resource extraction. If I could have the next slide, please. Resource extraction essentially entails the withdrawing of materials from the environment for human use, including fossil fuels like oil, gas, and coal, rocks and minerals, biomass, and water. It's important to note that the use of natural resources has more than tripled since 1970, and the demand continues to grow. Climate change concerns due to resource extraction are well documented. We all know that there's a well-documented connection there. And there are some estimates that the extraction and processing of natural resources make up half of the world's greenhouse gas emissions while contributing to more than 90% of biodiversity loss and water stress impacts. The extraction and processing of just metals and other minerals is responsible for an estimated 26% of global carbon emissions. And it's estimated that these problems will only increase given the mineral intensive nature of the clean energy transition. So that's going to require vast amounts of copper, lithium, and other metals in the coming years. So whatever problems we have with extraction now are going to double, triple, quadruple over the next couple of decades. So regardless of the exact figures, we can agree that these projects are major contributors to environmental harm. If you could just go to the next slide, please. Another point worth mentioning is that there are many such projects distributed around the world, if you look at the map. So extractives play a strong economic role in at least 63 countries, but from the map, you can see that actually many nations around the world engage in commercial resource extraction. So if you're looking at a country's GDP, maybe 1% or 4% of the nation's GDP doesn't seem that significant. But if you look at 1% of the GDP of a country like the US, which has a GDP of 21 trillion, that's still a sizable industry. It's a $210 billion industry. And given that global water resources are interconnected, the impacts of resource extraction may not be localized in many cases, especially when you look at how many nations around the world are engaged in extraction. And of course, countries differ greatly in their approach to environmental regulation and project development approval. They implement different standards and controls. So the potential for global impacts or impacts being felt elsewhere on water resources is quite high. Next slide, please. So even where there's evidence that a project will have significant environmental impacts and other social harms, often we see this is weighed against the national interest in economic development, which usually slants heavily in favor of development approvals. And then if you have decisions like this that don't align with public stakeholder values or where there's other serious environmental or human rights impacts, then these projects can become a deep source of conflict and controversy. And we're seeing that resource conflicts have become more frequent in recent decades. They've sort of become this proverbial battleground over the appropriate balance between economic priorities on the one hand and environmental and human rights concerns on the other hand. But they're also really interesting to look at because they can tell us a lot about a legal or political system. Resource conflicts touch on a broad range of matters from environmental science to economics, employment, human rights, indigenous rights. They often reflect a broader reality that exists in society. So a lot can be looked at how resource conflicts are resolved or not. Next slide. One of the case studies I looked at in my research was the Veladero gold mine in San Juan province, which is close to the Chilean border. So this region contains one of the largest gold and silver deposits in the world. There are a number of multinational companies operating in this area, including Barrick Gold, a Canadian multinational. But despite the significant economic potential of these projects in San Juan, they've been mired in social conflict almost since the beginning. The mineral deposits are located in ecologically sensitive areas where many rock glaciers can be found. So there are significant water, health, and climate implications from the blasting activities and the use of certain chemicals. And it's important to keep in mind that these glaciers provide up to 60% of Argentina's water, and their rapid melting at higher than normal rates contributes to rising sea levels. In other words, there's a potential for global impacts. Local communities and environmental scientists and activists took up this issue on a number of levels, and it's interesting to see how constitutional environmental rights entrenched within the Argentine Constitution supported their efforts. These constitutional environmental rights were operationalized in a number of ways, which we'll get into shortly. But the Veladero project is a really fascinating case study because we can look at sort of at the legal system and sort of the political context and also the economic context in great detail, in depth. Just to backtrack a moment, the environmental rights were incorporated into the Argentina Constitution during constitutional reforms back in 1994 in a pretty comprehensive way. Article 41 of the Constitution begins by guaranteeing that all inhabitants enjoy the right to a healthful, balanced environment fit for human development so that productive activities satisfy current needs without compromising those of future generations. It also imposes a duty upon all inhabitants to preserve the environment. In addition, it addresses environmental damage and ensures that the obligation to repair it should be treated as a priority. So it incorporates the polluter pays principle, and it prohibits the entry of dangerous, potentially dangerous, and radioactive material into the country. The Constitution also mandates that the authorities shall provide for the protection of this right, for the rational use of natural resources, and for the preservation of the natural and cultural patrimony and of biological diversity, and for information and education on the environment. And Article 41 basically mandates that the national government is responsible for enacting laws containing minimum environmental protection standards that apply across the country to make sure that inhabitants enjoy the same guaranteed minimum standards. And then the provinces are responsible for enacting laws to implement those environmental standards. So you can see there's a fair bit to work with there. We have a substantive right to the environment, we have procedural protections, we have individual responsibility, and we have government duties. An interesting historical point is that the inclusion of environmental rights was not really well thought out by its drafters back in 1994. They were really more focused on devising a constitutional framework that would attract foreign investment. And so human rights experts were not involved in drafting it. They didn't really fully consider the repercussions, but the consequences have been profound for the communities that have used these provisions, and for resource development companies as well, and for federal and provincial governments. Next slide, please. Before we delve into the case study itself, we just want to briefly mention how power over environment and resources is divided between the national government and the provinces. It's really important to understand certain aspects of the conflict. So in Argentina, natural resources, like in many federalized countries, are managed by provincial governments. So as a federal nation, Argentina's provinces grant mining, oil, and gas property rights and environmental permits. And they're in charge of applying a federal mining code and conducting environmental assessments. The provinces can enact their own local environmental legislation so long as they respect the basic environmental standards of the federal government. But in pro-mining provinces like San Juan, environmental controls can sometimes take a back seat to policies that promote mining. And there's also resistance in some provinces to national environmental regulation, as we'll see in the Veladero case. Next slide, please. So Argentina has a lot of mining potential, and most of the deposits lie along a 4,500 kilometer stretch of the Andes mountain range bordering Chile and Bolivia. There has been a great deal of political will behind developing these resources, and the Argentine government has worked to attract investment by introducing tax incentives and lower royalties. And this region is said to be one of the most important gold and silver districts in the world. So we'll be hearing a lot more about it in the future, I think. There are two mega deposits in San Juan, Veladero and Pascalama, which actually is across the border. It straddles the border between Chile and Argentina, with the larger portion of that one located in Chile. And these are vast open pit gold and silver mines. The project Veladero is operated by Barrick Gold, but in recent years has become a joint venture with the Chinese company. Next slide, please. So most of these mining projects, including Pascua-Lama and Veladero, are surrounded by hundreds, if not thousands, of glaciers in the Andes Mountains, which supply Argentina's water and are critical to ecosystem survival. I'm not sure if we've skipped over a slide. Yeah. I may have, it's okay, we'll just go to the next slide. So the Veladero mine continues to operate, but the project has been plagued with many problems, lots of ongoing concerns like rapid warming of glaciers due to explosions from mining operations, pollution of groundwater, among other things, and plenty of litigation. So out of concern, environmental organizations began to pressure the government for a law to protect the nation's glaciers. The national government tried to pass a law to prohibit all activity that might cause harm, including mining and drilling for oil and gas. So all operators would be required to do an environmental impact assessment. And if that assessment showed any risk of harm to glaciers, they wouldn't be allowed to proceed with the development. The Institute of Nivology, Glaciology, and Environmental Sciences, or IANGLA, was charged with creating a nationwide inventory of glaciers. And basically that would allow them to vet investment projects in the area and halt ongoing extraction in glacier zones. So basically we have a law that says, if you have any development going on in or around glaciers or that might impact glaciers, it cannot proceed. You have to have an environmental impact assessment to see if there are impacts, and we have to create an inventory of all of the glaciers in the country so that we know when we're impacting a glacier, so we know where they're all located. So long story short, there was a very long, drawn out political process and a social process in getting this law passed. Initially, it was resisted by the provincial governments and others who had a financial interest in mining activity. Some of the mining companies took out very expensive ads, engaged in advertising campaigns to try to change the mind of the public and to have them, withdraw their support from this kind of legislation. And they argued that it would slow down economic development, but also that the law stripped the provinces of their control over natural resources. So they made a constitutional argument based on a federal division of powers. Supporters of the law argued that the issue is a human rights one, that large-scale mining strips citizens of their right to water and their right to a healthy environment. And despite fierce opposition, the Glacier Protection Law was eventually passed in 2010. Then the inventory was started in 2011. It was carried out using satellite technology. As of 2018, IANGLA had registered about 16,900 glaciers, which are now precisely identified and fully protected by the Glacier Protection Law, which then has profound implications for the future of mining in Argentina, since operations are prohibited anywhere near glaciers or permafrost. The glacier inventory is considered to be the most authoritative document indicating where those no-go zones are for mining. So as a result, some new mining projects have to undertake glacier impact studies to see if they can proceed. And then ongoing activities have to be subject to environmental reevaluation. Next slide, please. So, of course, this led to concerns in the mining industry, as you can see from this headline. Will glaciers be for mining in Argentina what an iceberg was for the Titanic? So lots of concern in industry about what this means from an investment standpoint. Next slide, please. So, so as I mentioned, there was a lot of resistance to enactment of the law by mining companies. They spent millions on these newspaper ads nationwide, urging lawmakers not to support the bill and lobbying legislators from the mining provinces. But once the bill was passed, certain mining companies then engaged in a legal battle, claiming that the law was unconstitutional. Barrick Gold filed an injunction with the federal court in San Juan, arguing that the law was unconstitutional because of its impact on economic activity within the province. So it was really a division of powers federalism argument. The Federal Circuit Court judge suspended the application of the law to mining operations in this area, basically allowing Barrick to continue its operations. The court did this by finding that the new law created uncertainty and lack of tranquility for mining companies operating in glacier zones. So that was the language they used. Another company, Xstrata Copper, obtained a similar injunction for its El Pachon operations. So eventually the matter goes to the Argentina Supreme Court, which reversed the injunction and finds that the National Glacier Act is to be held in full force and effect, that it applies to all mining companies operating in Argentina, that the injunction itself was poorly justified, the injunction that was granted by the lower courts, and that basically mining companies also have to comply with legislative requirements, including the obligation to file glacier impact reports. So basically, the Argentine Supreme Court supported the constitutional validity of the glacier protection law and found it to be constitutional on a number of grounds, including the fact that it was enacted in furtherance of the government's obligations under Article 41 to protect the environment. But despite the legal victory, there were still problems. Next slide, please. So based on Argentina's division of powers, natural resources are within the domain of the provincial governments. They're not federally regulated. So the glacier inventory mandated by the federal government was carried out in a coordinated manner with provincial governments. And the provincial governments are responsible for conducting environmental impact assessments and regulating that. So the federal government enacts a law saying all of these have to be protected and we need a glacier inventory. The provinces have to coordinate to create the glacier inventory. So the end result was that a large number of glaciers in mining areas were not being documented by the provinces. So you'd find, there's thousands of glaciers being documented, but there would be little areas around the mining projects where there would be no glaciers documented. So a number of advocacy groups started using satellite data to verify whether or not the official inventory was accurate or not. So after the Supreme Court decision, Barrick claimed that mining at Veladero did not, in fact, take place on glaciers because there were no inventory glaciers in the area. So the debate prompted the provincial government to create an environmental audit committee to assess Veladero in light of the recently upheld legislation. And the province also passed its own law in 2012 to make an inventory which would cover glaciers, but not periglacial areas. So it took advantage of an ambiguity in the national law to carry out its own provincial environmental impact assessment, which, despite sharp criticism, concluded that the mines could continue operation because they didn't affect glacial areas, which then led to accusations of bias and inaccuracy in the provincial government's approach to the inventory. The Center for Human Rights and Environment alleged that the province carried out this glacier inventory that was very limited and imprecise. It didn't include geographical coordinates. It omitted a 15-kilometer strip where most of the mining was located. So Veladero continued to operate, and it was viewed with suspicion by locals and scientists alike. On the other side of the border in Chile, Pasco Lama never became fully operative because of a number of legal challenges over similar issues. But on the Argentine side, it was still operating. Then in 2015, 2016, and 2017, there were a series of accidents that spilled millions of liters of cyanide solution into public watersheds. These accidents led to a brief shutdown of the mine and a criminal complaint, which local activist groups lodged against Barrick for environmental damage and against the state for failing to act. The accusations against Barrick ended up in provincial court, where a friendly judge let the corporation off with a minor fine. But interestingly, the accusations against the state led to federal indictments against government officials. And this is where we start to see some of the benefits of Constitution entrenchment in action. It's in the realm of government accountability. So even though mining companies and the provincial government relied on this traditional division of powers within the federal constitution to support their actions, the existence of the constitutional right brought a measure of accountability into the exercise of power. And I would argue this might be where we see the real benefits of constitutionalization. Next slide, please. The spills led to public outcry. And in 2017, there was a federal judge who indicted 3 former government officials and Ricardo Villalba, the country's leading glaciologist, who had initially advocated for the National Glacier Inventory and supervised it. And they were all charged with allegedly abusing their authority and failing to properly enforce environmental law. They were accused of delaying and deliberately narrowing the scope of the inventory. And Villalba advocated for and supervised this. And so essentially they're saying that he didn't do it correctly. And the argument was that if the inventory had been properly carried out, the mine would have been shut down and the spills would have never happened. And that there was a failure to inspect Valadero specifically, and there was a delay in the publication of inventory results. But most importantly, the indictment takes issue with how glaciers were inventoried based on technical standards. And Villalba and the government were alleged to have only inventoried bodies of ice greater than 1 hectare in area, based on current international standards that were applied by the UN-affiliated World Glacier Measurement Service and Global Land Ice Measurements from Space. So these are international standards that they applied. But according to the indictment, this contradicted the language of the glacier protection law itself, which spoke of mapping all glaciers and periglacial areas. So advocates were basically saying that everything should have been documented because that's what the legislation required. And that alone should have triggered an assessment of whether mining should continue. Villalba, in his defense, suggested that the reasons for delay and inaction were political and institutional rather than technical, which may have some real merit given the provincial government's resistance to implementing the law, which for some reason hasn't been factored into the indictment. And perhaps the indictment targeted the wrong regulatory body. So how that plays out remains to be seen. And the criminal cases, last I checked, hadn't yet quite been resolved, but regardless, they highlight the fact that considerations of the substantive right to a healthy environment are brought to the forefront as the courts look to how governments actually implement the right and whether or not these measures are effective, rather than simply getting caught up in whether procedural requirements have been met. Next slide, please. So in essence, we see how constitutional environmental rights are operationalized within the context of an actual conflict. So first, we have constitutional provisions that impose an obligation on the government to develop legislated minimum standards for glacier protection. We have a glacier protection law that requires existing and new operators to complete environmental impact assessments, and which makes it illegal to mine in glacial areas. And mandates the creation of this glacial inventory for monitoring and enforcement purposes. When mining companies and provincial governments who are pro-mining challenge the constitutional validity of the law, the courts uphold it on the basis of constitutional environmental rights provisions. And then these provisions create avenues for the public to raise their concerns about environmental impacts. So anyone can file a suit without having the requirement of showing personal harm or meeting stringent standing requirements. The environment remains at the center of consideration in these cases. And then where there's non-compliance with the Constitution's environmental provisions, that can then support the imposition of criminal sanctions against public officials for failing to comply with constitutionally mandated environmental protection requirements. So in the case of glacier protection, where mining accidents occurred that harmed the glacial environment, criminal investigations were launched, a number of public officials and mining employees were charged. And even though mining is still occurring in this area, the constitutional environmental rights provisions can contribute to greater accountability and even more oversight by the courts in terms of the standards that are applied to these projects. Next slide, please. I'm thinking about skipping the next breakout session and instead finishing up and then having a discussion and taking questions. given the time. So next slide, please. So what does all this mean? You know, what can constitutional environmental rights offer in terms of protecting water resources and the public's right to them? I would argue that constitutional environmental rights at the domestic level have some advantages over international law mechanisms. Apart from issues of enforcement, they can encourage deliberative and democratic environmental governance. Domestic protections of this sort may also provide the best protections for the environment, because the people who have the most at stake and have the highest levels of motivation to defend the environment and water resources may also have the greatest amount of knowledge about their local environment. And I think that's an important factor to take into account, making sure that they have the appropriate legal mechanisms at their disposal. And apart from that, Veladero shows us that even where people are not directly or immediately impacted, they will still pursue action in court to protect the environment if the barriers to do so are lowered. So constitutional environmental rights provisions can allow for that. So when we consider these benefits and go back and look at the number of nations that engage in commercial resource extraction that have also enacted constitutional environmental rights protections, the possibilities really open up. So if you could just go to the next slide. So those are the resource nations or nations engaged in extraction to some degree. And then if you go to the next slide. Over top of that are, these are the nations that have constitutional environmental rights. Next slide, please. So now you can see the extent of coverage of constitutional environmental rights provisions relative to nations that are engaging in extraction. So many of the nations that are engaged in extraction have some type of constitutional environmental rights protection. You can see which ones have none: the United States, Canada, Saudi Arabia, Pakistan, and a few others. And the light green, I would argue, perhaps are not as effective, but there might still be room to argue for an implied right, you know, with the courts. And I know in some countries like India and Pakistan, they have argued this with some success. But really, we're seeing the potential spheres of influence for addressing and mitigating impacts on interconnected water resources here. So by strengthening the effectiveness of existing domestic constitutional environmental rights mechanisms, and by increasing the number of countries that recognize these types of rights, to include countries that are missing, like Canada and the US, we can systematically and incrementally address the harm caused by development activities. So this human rights-based approach is gaining momentum around the world. It has a potential to have a snowball effect. So from a legal perspective, I would argue that constitutional environmental rights are critical in our efforts to address the sheer magnitude of the cumulative environmental and social impacts of development. So an important piece of the puzzle that I think cannot be ignored. Next slide. So I'm just going to wrap it up here. It's nice to have a little bit of time for discussion. So any comments, thoughts, questions? Happy to take those.
Asmaa, to start us off, we do have one question we've received. I'll just read it out to you. What are the implications of the universally recognized right to a healthy environment, such as the Human Rights Council resolution adopted last October? Can people living in countries whose constitutions do not recognize this right use the Human Rights Council resolution to assert their right? I hope this question makes sense to you.
That's a really great question. Until it becomes encapsulated in a treaty and a nation becomes a party to that treaty, there's very little scope for enforcement of that right. But international recognition still plays an important role in motivating domestic governments and domestic courts to to reflect on what the international standards are. So for example, in a country like Argentina, international law is also applicable domestically and constitutionally recognized. So Argentina's constitution actually does recognize and import the values of international treaties and norms. And the judiciary regularly makes reference to international standards. So even if you don't have explicit importation of international human rights norms in domestic law, it's still very important. It may not be specifically enforceable as a provision, but still very important and can be relied upon by the judiciary to set new standards, to say this is an international norm, it's internationally recognized, and therefore perhaps we will read in a right into other existing provisions. So it can help support those kind of arguments in that way. Any other questions, thoughts?
We do have a one hand raised. Dina, your hand is up. Go ahead.
Thanks for that really fascinating talk, and it's a really interesting case study. I really enjoyed learning about it and learning a little bit more about Argentina's sort of legal framework. I mean, one of the things that seems like very clear from your talk is that you can have the constitutional protection, but there's just got to be this huge, like, functioning system of constitutional enforcement and protection that goes around that, subsidiary legislation and justiciability and standing in court to proceed in these sorts of matters, and of course what I think we saw in our breakout group was when those things begin to when you see deterioration in legislative bodies and judicial bodies and administrative bodies, then the rights become less kind of meaningful. Their implementation becomes kind of less and less possible. But I was also wondering whether there's a risk of it going the other way, whether when one has sort of lofty and ambitious constitutional provisions, and I apologize for this question, I'm a bit of a pessimist, this question reflects it, but when one has the sort of ambitious constitutional provisions, whether there isn't a risk that they stand kind of in tension with states that want to engage in resource extraction, whether they don't kind of rub against good institutions in a way, whether states aren't motivated to undermine the very institutions that ought to be upholding those rights. Sorry for the bleak question.
No, it's actually one that many have. I would argue that constitutional environmental rights are sort of the starting point. As you highlighted, you still need an institutional framework. You still need a judiciary that's willing to work with those provisions and not take a hands-off, conservative, non-interventionist approach. Of course, there's arguments on the other side that you don't want a judiciary that's too activist, because that can undermine development, which is also critical for nations. And I don't think that these environmental rights provisions necessarily undermine development. I think what they call for is a more sustainable approach that considers the human rights implications, the environmental implications of this development. So particularly in Latin America, say, mining companies will sometimes just use the cheapest technology available. They're not as focused on reclamation. They're not as, the environmental impact assessments may not be as thorough or as properly deliberated. So I think where constitutional environmental rights offer value is in supporting a more deliberative approach. There are many mining communities that are pro mining. They see the value, the economic benefit. We're going to need mining for the energy transition. There's no way it can happen without it. We need vast quantities of lithium and other materials. So, I mean, the real question is, how do you strike that balance? And historically, mining communities are often vulnerable, they're disempowered, they don't have much of a say. So as we see in Argentina, the mining hasn't stopped, it's still ongoing, but there's an opportunity for community stakeholders to say, we don't want all of this cyanide in our, or cyanide solution in our drinking water. You know, you have to do better, and there has to be some accountability. And in a lot of places, accountability and transparency is a major issue. So I don't think that constitutional environmental rights are the be all and end all. I think they're a starting point. You still need to bolster institutional approaches and strengthen them. But accountability is an important issue in resource extraction in particular. I don't know if that really addressed your question, or I don't think anyone really has all the answers.
No, that was great. Thank you.
Any other thoughts? Okay. Well, I mean, this is one case study. There are many others. One I'm looking at right now is Costa Rica, another gold mine. Another really interesting one that I came across was in Argentina in relation to the Mendoza area, where mining came into conflict with wine producers. And the local wine producers association took issue with these open pit mines and the impacts on water and what that would mean for their industry. So these are really important cases that, you know, will highlight the potential. There are also many examples of nations with constitutional environmental rights protections where those provisions are they're just considered aspirational and not really operationalized. So some of my work is really just focused on looking at how are they operationalized, and what does that mean for, you know, for constitutional environmental rights more broadly. So that's pretty much it.
Yes, thank you, Asmaa. I don't see any other questions. Oh, I'm sorry, I see a hand from Dina. Oh, it's not a hand, it's clapping. Okay.
Oh.
It's clapping from Dina. Since there are no more questions and no more raised hands, we just wanted to thank you so much for this. Honestly, it was a great lecture, super interactive on a topic that's important both for the network and for UNEP as well. So we're looking forward to hearing more about your research, and if you're okay with us sharing your slides with all the participants, please do let us know. We'll make them available on the website then. And just to thank you all for connecting and for joining us for this lecture, and to remind you also that we have a full program in, I think, 2 hours, or maybe it's an hour's time. I'm trying to do the conversion in my head. It's at 4 p.m. Nairobi time, 3 p.m. Vienna time. We have another moderated discussion on water and sanitation as human rights. So if you haven't registered, please do. And we look forward to seeing some of you on that during that lecture as well. Dina, did you want to say anything in closing?
Just many thanks. That was really fascinating. I think it cut across a kind of range of issues, and it really brought the theme of water sort of usefully. It did one of the things we really want to do in the school, which is point to the way in which water is just an aspect of every part of thinking about and understanding the environment, and thinking about our kind of regulatory and legal framework for managing the environment. So thank you for that. Thank you to Angela for moderating, and we'll see you all at the next session when we talk about water and sanitation.
Thank you both, and thank you all for attending. Hope you enjoyed that.
Okay, bye everybody.
Bye.
Bye-bye.